Certainly.
So we're going to begin with estate planning, and I'm going to basically ask Michael to, and I'm going to have each of the panelists for each of the tracks make an opening statement around that particular area of discipline. So at this time, take it away, Mike.
Okay, you're in the Paul Brest Hall, right? That's the name of the hall. Paul Brest was my constitutional law professor when I was at the Stanford Law School. And when Larry mentioned the professor asking questions is called the Socratic method, when he just mentioned it, my throat constricted. You know, when you're a student, you're so weak. You just feel like you're just being victimized. But I'm beyond that. That was 1973, so I'm way beyond that. So actually it was then that when I got out of law school, I started a free legal aid program for the elderly and disabled, and I've been in that field for quite a few years. My focus is going to be on special needs trusts. We work with families to do their estate, to basically put together plans to take care of their families, to make sure their assets are protected for their kids, their grandkids, ideally for multiple generations. So it's multi-generational planning. And the area of special needs has been an area of focus forever. Our rough count is we've done somewhere between 800 and 1,000 special needs trusts and counseling families for literally decades. So it's a matter of not just understanding government benefits, which we do, but really understanding multiple tax issues. Income tax, capital gains tax, estate tax, gift tax, property tax, goes on and on. So just kind of underscoring the fact that the area is complex. It's not just setting up a special needs trust. It's really understanding how it fits with a family's plan. And as Larry said, it's really got to be a life plan, particularly for folks with any form of a disability. So with that, I'll eagerly hear any questions.
Well, I'll lead off with a couple of, starting out with some high-level questions, because the group of this size, there's going to be some of those that are almost subject matter experts on this subject, and you're trying to tune up your thoughts around, let's say, things like special needs trusts. And I know there's people here that really, frankly, didn't even know what a special needs trust is. So, Mike, if you could just briefly just give us, the 35,000-foot view. What is a special needs trust?
So the question is, when we pass, because again, our plan is to never die, that plan is probably not going to work out. So the question is, how do you organize things for the protection, again, of all your family members, but our focus today, is on a child with a disability. So fundamentally, you have two choices. You can leave money directly to that child, which would cause them to lose eligibility for so many government benefits. You have to qualify for something called SSI, Supplemental Security Income, Medicare, other programs. Generally speaking, can't have more than $2,000. So if you leave that child money, they're going to lose eligibility. It's chaos. The money could be wasted. So the alternative, the thing that everybody should do, virtually everybody with this circumstance, is you create a special needs trust. It can hold any amount of money without disturbing eligibility for government benefits. It can hold real property, it can hold a residence, it can hold cash, it can hold stocks, anything. Somebody will be the trustee. They will manage the assets for the quality of life of the beneficiary. They have to understand the basics of government benefits so they don't interfere with eligibility. There's our book out here gives a lot of guidelines about that. So the person that is chosen as the trustee, the person to manage the trust, is really the key person in the beneficiary's life. I think we can summarize a special needs trust actually in two sentences. And these are the sentences that are directed to the trustee. So if I'm the trustee of the trust, this is what the trust says to me. First sentence, it says, trustee, it says, you can't use any money in this trust to pay for any item or any service that some form of government benefits is adequately providing. Can't do it. Sentence number two, if there's something this individual needs that is not adequately provided by government benefits, bless you, use the money liberally and take care of him. There's your special. It's a little thicker when we draft it, but those two sentences really summarize it.
Excellent. I'm going to ask Mercy, who also deals with this area. There's the question that comes up about how much or how little to put into a special needs trust, and obviously that's going to depend on very specific circumstances, but is there some general guideline around how to, and this also crosses over to what Dan does, who manages the assets in a trust. So there's, see this, you can see the organic nature of these professionals needing to work together as a team for our benefit. So,
sure.
So probably the first thing I would do would be to send them to Dan and saying, you know, you really have to develop a financial picture of what the child's needs are going to be. And sometimes that's difficult to know, particularly if you have a young child, and you might not know how they're going to be functioning when you ultimately pass away. Hopefully that's many years in the future. So you want to come up with a financial plan that includes how much do I put into the special needs trust. And you probably are going to be addressing what happens if something happens to me tomorrow and what happens if something happens to me 40 years from now. The other piece that I often discuss with clients is, do you have other children? What do you intend to leave them? And that will all play into that financial piece.
Excellent. There's some changes going on, and this is why you could come here today, and a year from now, the landscape just around this one subject area could be different. And this is why this isn't something that you do once. This is really a living plan that can take advantage of new laws or it be compromised by the direction. So there's actually something that's brewing called a self-directed special needs trust. And I'm just going to throw that out to whomever would like to answer that on the panel. And basically it says that under equal protection of the law, individuals with disabilities that don't have a caregiver or a family member or a conservator to act on their behalf, actually there's a movement underway for them to actually be able to set up their own special needs trust. So I'm going to throw this to the panel if somebody would like to. It isn't in existence yet that I know of, but could we maybe help them understand that something might be coming?
Okay. So I'll comment first. So the law now, existing law, already says that a disabled adult can put money, his own money, into a special needs trust, any amount, and not disturb eligibility for government benefits. Now that person can't be the trustee. It's called a first party special needs trust. A parent, a grandparent, a court order can create it. A disabled individual can't create it yet. However, we just had something called the Special Needs Fairness Act, I think it's called. So basically, we do have legislation now that does let a disabled individual create a special needs trust and put his own money into it. So we have that, but not be the trustee. So, you know, I've talked with some individuals who wanted to manage their own money, angry that they can't manage their own money. And my personal experience is that while I understand the motivation, conceptual, I don't think it's a good idea. I mean, I understand independence. I really do. You know, I'm all for it. But objectively, a special needs trust ideally is going to last for somebody's lifetime. And that means there's got to be constraints. So I tend to be very, very conservative about these issues. Again, those who know me, you know, we've fought for the rights of older people, disabled. Believe me, I get that. But here, boy, do I put on a conservative hat. So I would want to very strictly limit. I'd be very wary. I'd be very careful before I would endorse that and say, boy, that's an awesome idea. Even though in other forms you might have to get out with your scalp.
And I would also tend to concur with Mike's position. I would tend to be very conservative about that. And I think you do have to ask the question, what is the individual's, you know, capabilities? And perhaps there are differences for, you know, somebody who's very high functioning, and are they subject to undue influence? And I think that you would have to be very careful about that person's money then being used for other individuals.
Now, what I could see, by the way, is that somebody could be a co-trustee. You can write a trust any way you like. There can be co-trustees. You can allocate certain powers. This set of powers go to this trustee. This set of powers go to that trustee. You can limit the size of a check that can be written by one trustee. So, you know, so I think you can envision involvement that would be very supportive, very proactive, and yet, you know, arguably stay away from the dangers that I think we're identifying here.
Dan, anything you want to add to that?
Yeah, I think a lot of the accounts that we work with a lot of private professional fiduciaries, so they act as trustees for the special needs trusts. And oftentimes they're put in place because there is maybe an elder or somebody who has had undue influence. So when you see things like that, it's very difficult to come to you know, a conclusion on, you know, is this the right thing or is it not the right thing to do? So in working with a lot of those clients and those fiduciaries, you know, I feel it's good to have them helping through the process. And if you had a co-trustee with them, I think it'd be something they'd be amenable to. But I think that, you know, working with a professional is a good way to go.
Jim, anything to add to that?
Not really.
Okay. We have a question on the floor over there.
Yes, can you have a remainder
Could you stand
provisions?
up and stand up so that we can
Hi,
get you
I'm
on,
Bill Austin.
on video and you can become famous?
Can, can you have remainder provisions in the trust?
The question is, can you have remainder, I assume you mean, can you control where assets remaining in the trust go when the beneficiary dies?
Correct.
Absolutely, I mean, you do set that up. So 90%, I don't know, 80, 90% of special needs trusts are created by parents or grandparents, some third party for the benefit of the individual. In those trusts, there's no payback to the state of California. So when you create the trust, you would specify who gets the money remaining in the trust. It can be your favorite nonprofit, it can be other kids in the family, it can be anybody. The other type of trust that I actually mentioned is this first party special needs trust where the disabled adult's money goes into the trust. For that type of a trust, you can still identify the remainder, but the state of California has first crack at the money to be reimbursed for money that the state put out. So there's two different types here, different answers.
On the back?
Hi there. If your disabled child is working, can they put their earnings in a special needs trust and then it's not considered part of their income for housing or other eligibility for government benefits, so that they would just put their earnings immediately into the trust for savings later?
Okay, my first response is that, I mean, the definition of disability in the context of government benefits is basically an inability to maintain substantial gainful employment. Can you get and keep a job? So if you're working and making there's programs that allow you to work and maintain eligibility. So maybe, I mean, that has to be what you're talking about. Otherwise, you know, you're working and you really don't qualify as a disabled person. So your income is not that sizable. And you'd almost have to be fitting into one of the government programs, like there's 3 or 4 programs that allow you to work, even though you're getting SSI, supplemental security income, and other government benefits. But the bottom line is, if you have that income, unless you're in one of these programs, it's going to count. So it could reduce your SSI check, it could increase your Section 8 payment, rippling effect.
Yeah, if I could just add also, I think Social Security would probably, if the person is on means-based benefits like SSI, not SSDI, but supplemental security income, the month in which they receive it, as Mike said, it would be considered income. That would reduce the SSI benefit 2 months later. But then also, if they took that money that they earned and put it into a trust, I think it would be looked at as gifting it away in order to remain eligible. In other words, they're holding down their resources below the $2,000 level by gifting the money to another entity, even though it's their own trust or a trust in their name. I think Social Security would look at that as gifting it away, and there'd be a period of ineligibility as a result.
Yeah, one of the great ironies in the program is that if you make a gift, it can create a period of ineligibility. If you spend it, no sweat. Enjoy the money.
And there's something new that's called the ABLE Act, where you might be able to put some of that money into that. So therefore, you wouldn't have to worry about those minimums.
That's a great segue. I wanted to ask Jim and Dan to comment on the ABLE Act. At first, for those that aren't familiar, it's an acronym. It means a better life experience. Whoever came up with that, but that's what ABLE means. But there's also been some changes in that, so maybe Jim and Dan explain a little bit, what is the ABLE Act and what has happened to amend it with the ABLE Work Act, because they're expanding how much you can put away. So I'll let you guys.
I'll start on it, and then maybe you guys can come
Or
on
see,
that too.
weigh in on that.
So when it was first put into place, you know, it has to go through legislation first, right? And I think they wanted $250,000 that you could put in there, and that Medi-Cal wouldn't have a clawback eligibility on the assets. But now, after going through Congress, I don't know how many years it took, the limit is $100,000. So you can only put $100,000 in there. If you put $98,000 and the portfolio grows, because your financial advisor did something good, then you're ineligible for government benefits once it hits over that $100,000.
So does that mean they should employ you because you're good, or not because you're good?
Not me, your financial advisor. So it's really one of those things you have to watch. You have to watch it closely. So The other issue with the ABLE Act is I think it's one of the things, it's another tool in your quiver, or another arrow in your quiver, in using it with a special needs trust. So if, like I said, if it gets over the $100,000, there's an issue there. But the other issue is if you pay for medical care, at the end, Medi-Cal has a clawback and they can take back that money, just like in a first-party special needs trust.
Add anything to that? Just a couple things. The ABLE Act, by the way, is only basically enacted in 4 states. It's scheduled for California in the summer of 2017. But it is an alternative for those under their family circumstances to have something special needs trust like, so that they can actually put away more money without violating the eligibility for public benefits, which Jim spends his whole life focusing on. So this gives families another tool. And also, there's a new layer being put on called the Able Work Act that says, because right now you can put away $14,000 a year until you hit the magical 100. But now you can now work and earn $11,700 a year, I believe is the number. And so you almost can double the deposits into the account when the whole act comes into being in the case of state of California. So that means you can accelerate your deposits, but it isn't going to change at the moment the upper limit of 100. But it is really something for families that aren't familiar with it to really begin to research, because it should become available if the powers that be in Sacramento get their act together to pass it in and act it for. It's a federal law that will become available at the state. So this is something to watch. And this is, again, this is a dynamic process. Why you can't just say, I've got it all figured out today. You really got to be plugged into the community of like-minded and like-situation families, because there's opportunities on the table that people like Jim can really help you be aware of and take advantage of. So that was great to really show how many people, just as from a professional point of view, are touched by these kinds of acts. There's a question over there.
I have 2 questions about ABLE. Hi, 2
You're next.
questions about ABLE. In terms of if you already have a special needs trust, how do you see them interfacing with each other? I'm talking about tax advantages. And the second, or if there's any other advantages when you have already the trust. And then the second question is since California seems to be very slow in rolling out the ABLE, I'm looking at other states and they've already got it, do you recommend or think that maybe going to another state, because I understand you can open an ABLE account in another state, is advantageous, since we're not sure when California, they said maybe summer 2017, but I'm not holding my breath.
Mercy, can you shed some light on that?
In terms of I think maybe Mike can speak to the
Okay.
tax issues.
Yeah, one thing that is a very good thing about the ABLE. There's many things that are good about the ABLE Act. I mean, I was focused on a special needs trust. It's complementary. It adds on. It's not so bountiful that it can ever replace the special needs trust and adequately funding it, but it is a $100,000 cap. Okay. You're all aware of the so-called $14,000 annual exclusion. That used to be $10,000. You can give that away. You don't have to report it to the IRS. It's a freebie. You can't make those gifts, those unreportable gifts to a special needs trust, because it's an irrevocable, a little technical stuff here. But the ABLE Act is something where a parent, a cousin, a friend, anybody can make this $14,000 transfer into an ABLE Act and not have to report the gift to anybody. So that's like kind of a tax advantage you have with the ABLE Act that you don't have with the special needs trust. And there's some income tax advantages that I think are relatively minor. But that's the opportunity to me.
So, there was a question over here.
I was just to add to that. They're similar to the 529 plans. If you folks know their college education plans, so I think the state of Ohio was the first one to open up an ABLE Act. And living in the state of California, you can totally invest in the Ohio plan. It doesn't matter which plan, just like the same thing with the 529 plan. So in terms of investing, I think you can go with any plan out there that's capable. I don't think California is going to be ready by the time they say they're going to be ready. And I think that in focused on the plan, you get that tax deferred growth, just like a 529 plan, and then you take it out.
Please. And maybe if you have a particular panelist you'd like to direct a question to, please do so. If not, we'll
It's probably the folks on Special Needs Trust.
Okay.
If families set that up a number of years ago,
Open the mic.
10 or 15, or if we set one up now, is it something that we should be revisiting every few years because the laws change? You've said that a few times now, but if we've already got one, would you be advising that we look at them again and see under the current laws if they could be better for our child?
Absolutely, it should be reviewed. There's so many items that we would look at. Like one is, we strongly believe it should be, for example, a freestanding trust, not a few paragraphs incorporated into your existing revocable living trust, that kind of thing. And the other is you need to constantly check in on who the trustee is. Are you still happy with your choice of trustees? The trust is irrevocable, but if you haven't funded it, if there's no money in it yet, you can just swap it out, just replace it with a new one. And the question about the remainderment is very important. Who's going to get the money remaining in the trust if it's your child, when your child passes? Are you still happy with that plan? That evolves, and there certainly are some of that boilerplate garbage at the end of the trust that you think is so irrelevant. Some of that stuff has evolved, and it's important. So the law has indeed evolved. There's certain elements of a special needs trust that have to be there, so they pass muster if they're ever reviewed. The Social Security Office they have kind of a checklist of things they want to see in a special needs trust. So you should check it. You should make sure it's up to date and you're comfortable with all of your choices.
So amazingly, you can see that we're actually running out of time on this track, and it's like, wow, we're just getting started. This is like an iceberg. But that's why I'm saying really focus on the questions, because later on, as you begin to work your plan, you begin to really even begin to know what you need to ask Mercy and a Mike and a Dan and a Jim. So I'm going to honor one of the cards that came up that's relevant to a question that was just asked, and then we're going to have to segue, but we will have open forum, total open forum in the last track, so we'll do our best to cover this, but you guys are a fervent source of great resources. So this question says, how do you manage transitions in trustees? Do you need to line up a long list so that you basically have a whole succession plan of trustees over time in a seamless fashion? So it's just almost what you just said, Mike, but what do you think, Mercy? How would you handle, because I like to use a visual. So you stand there and you look at the horizon and you're on a railroad track. Well, the railroad tracks converge on the horizon, but intellectually we know, unlike the flat earth crowd, is that the railroad tracks each keep going around the curvature of the earth, but we can't see. So here we are today knowing that we're going to eventually hit that point on the horizon where we can't see beyond, but we got to have people taking care of our children. My son Peter's in the corner. He's 21 years old. I'm a little older than 21, and my runway's a lot shorter than his, and he's probably going to live at least another 70 years. And I know that pretty likely I'm not. So how do we address this problem of succession trustees?
Sure. So partly it's a function of what your personal situation is. If you have a group of individuals that you feel very strongly would do a good job of being a trustee, we would talk about putting them in place as perhaps co-trustees, successor trustees. The question you always have to be asking again is, what happens if something happens to me tomorrow? And also, what happens when something happens to me 20, 30 years from now? You always want to be thinking about those two pieces. And the person who would be a good trustee tomorrow is not the same person who would be a good trustee many years down the road. And in fact, the person who you decide right now might be a good trustee 20 years down the road may not in fact be able to do so 20 years down the road. So sometimes we put in some language that allows other people to make decisions. We might put in something called the trust protector, for example, with an authority to appoint a successor trustee if the people you have designated are not able to do so. Sometimes what we do is we will put in language that says a trust protector may appoint a particular category of trustee, for example. If you know that many years down the road the trust will be funded, there will be significant assets to support the individual, you may want the trust protector to appoint a professional fiduciary. The person you pick right now as a professional may not be in business 20 years from now, so you want to give somebody the ability to pick somebody with that skill level.
Excellent.